May it please the viewers, I'm Rich Schoenstein, and I'm doing something a little bit different. I'm here on a Sunday morning just to have a little chat with you about some of my thoughts about the Karen Reed case. I've got the weekend hair going. I'm a little relaxed, and I've had time to reflect on this verdict that came down last week. I have some thoughts about the verdict. I have some thoughts about what's going on right now with some of the jurors, and I have some thoughts about pending civil litigation. So let's get at it. First of all, the verdict. Now, I want to start by saying that I did not see this case the same way the jurors saw this case. I saw this case slightly differently based on the evidence, based on my view of what went down at the trial. But that doesn't matter because I wasn't on the jury. And there's a reason we do this the way we do it. We pick 12 people and some alternates, and we make them the jury. We give them the power. We put them in the courtroom, and they're there every day for the trial. I think this was a 6-week trial. Every day, every witness, every question, every sidebar. They are sitting 6 or 10 feet away from the witnesses. They are there to determine credibility. They are there to weigh the evidence. They are there to hear the arguments. That's their job. And we give them the power to make the decision. And their verdict and only their verdict matters. And it doesn't much matter that I didn't see the evidence the same way they did because they were the jury. Now, why do I think they reached the conclusion they did? Reasonable doubt. If you heard me talk about this case, and I've been talking about this case since the first trial, and I've been talking through the second trial, you have heard me say that I never liked the defense's conspiracy theory. I thought the conspiracy theory, the idea that he was killed inside the house, that John O'Keefe was killed inside the house and dumped on the front lawn, and all these law enforcement people cooperated and made up a story and framed Karen Reed. I found that really hard to believe. And in the first trial, I was very critical of the defense for leaning into the conspiracy theory. The first words out of their mouth in the first trial were that Karen Reed was framed. And I always thought that was taking on a burden of proof that the defense didn't need. What they needed in this case was reasonable doubt. And in this trial, this second trial, that's exactly what they did. They left behind the conspiracy theory for the most part. They alluded to some arguable shenanigans by people inside the house, but they didn't really dwell on it. They focused on the argument that there was insufficient proof, even that a vehicle hit John O'Keefe. And if there's no proof, not proof beyond a reasonable doubt that he was hit by a car, the case is over. And that's what the defense harped on in the second trial. And it worked. It worked. If you hear the comments of some of the jurors that have been spoken to, they didn't believe beyond a reasonable doubt that John O'Keefe was hit by a car, or that collision, if it happened, caused his injury. And it's the second part I thought was a major problem in the second trial. Think about it. There was no witness for the prosecution who testified that the cause of death was being hit by a car. I mean that. There was no witness that testified that the cause of death was being hit by a car. There were witnesses who testified that he probably got hit by a car. The prosecution had their own expert, the defense had experts, and they, contradicted each other. But the medical examiner didn't identify a cause of death, couldn't identify a cause of death. So there was a very big problem on the proof that he was hit by a car and or that collision caused his fatal injury. And the defense stuck with that throughout the trial and hammered on that. So that was an effective strategy. But beyond strategy, I think, there's something really fundamental here, which is Karen Reed is very wealthy, very privileged, white, female. She really had everything going for her as a criminal defendant. She was able to hire a high powered criminal defense team that included an experienced Massachusetts criminal defense lawyer, one of the premier trial lawyers in the country from California. And then they added, and don't sleep on Bob Alessi, they added a guy from New York to work on the expert component of the case. And the jury really liked him. And he was a good juxtaposition of the style of Jackson. And they really rounded out that team nicely. And they had Elizabeth Little, who is Jackson's cohort. They had a very high powered defense team. And those lawyers were just better. And I thought Hank Brennan did a good job. I really did. I thought the prosecution put on a much better case than the first time around. It was much more focused. It didn't go off on all these tangents with all these witnesses in the house who say they didn't see anything, so why are they even testifying? It was very focused. It had better expert testimony than the first trial. It had a better explanation of why they were pursuing a murder 2 count, although I still don't agree with it. It was a better explanation. They did a better job. The opening was better. The examinations were better. The closing was better. It was a better job, but it was also a better job by the defense. And at the end of the day, the defense won the battle of the lawyers and they won the battle of the experts. And if you've followed me at all, you know I don't love these ARCA guys. I sort of think they are dime a dozen expert witnesses. I've been practicing a long time. I've seen a lot of expert witnesses. They're fine. They're no better, no worse than anybody else. They were fine. They did a good job. I never bought the argument that they were completely independent. I know there was a lot of fighting about that, but it was pretty clear whose side they were on and who was paying them at the end of the day. They were fine. But in this trial, they were better than the Commonwealth's experts. And that doctor they put on at the end, the defense did, she was better too. The defense experts were just better. And then in the one strategic thing that I didn't understand at all, Hank Brennan didn't put on a rebuttal case. He let those witnesses, the doctor and the 2 ARCA witnesses, have the last word. He let them be the last thing the jury heard going in to deliberate. And what they said wasn't a collision. And they said it effectively. I know Hank Brennan scored some points on cross-examination, but he didn't demolish any of those witnesses. He didn't tear any of them apart, and he didn't put on any rebuttal. So at the end of the day in the jury room, you have kind of a circumstantial case, right? There's no eyewitness. There's no video evidence. I know there's pieces of taillight. That was good prosecution evidence. I know there's the alleged statements of Karen Reed at the scene and those videos. There was some good prosecution evidence, but the jury didn't think it was enough to prove guilt beyond a reasonable doubt. And I don't blame them, because add on to the top of all of that, you have the problem with law enforcement. You have the Michael Proctor situation. The lead investigator gets fired. His texts are read into the record. They are horrible. We all know they're horrible. There are law enforcement people who aren't called as witnesses. There are people in the House who aren't called as witnesses. There's so much here that the jury could glom onto in finding reasonable doubt, and that's what they did. And the closing arguments were very good. I thought both of the closing arguments were very good, but I got to be honest, Alan Jackson's was better. Alan Jackson's closing argument was magnificent. It really was. And it was convincing, and it persuaded the jury. And Hank Brennan gave a pretty good closing too, but it wasn't enough. No rebuttal case, the weaker experts, gaps in the proof. That is why this jury came back and found not guilty. And that may upset you, because you may believe from what you've seen and what you know that it seems pretty likely that Karen Reed hit John O'Keefe with her SUV and left him, and he died in the snow. You might believe that. It might be true. But the fundamental question for a trial is, was it proved beyond a reasonable doubt. Now, after the trial, we've heard from a few of the jurors. I haven't watched all of the juror interviews. I've watched snippets. I've seen some of their comments, and I know that people are getting after them. Lay off the jury. It is no surprise to me that a juror came out of that trial, saw all the hubbub, saw all the excitement online, and thought she might post some stuff on Twitter herself. It is no surprise to me that somebody cooped up a month and a half in that courtroom, finally allowed to connect with social media, might do that, might reactivate a social media account, might engage, might do interviews. I don't have a problem with any of that. That's their prerogative as jurors. They're free to talk. They're free not to talk. My experience is most of them don't. And I think in this case, most of them haven't. But the ones who do have every right to do so. And it doesn't mean we get to start tearing them apart and looking for inconsistencies and trying to create a case that the jury somehow did something wrong. I mean, imagine this. If you are an advocate, if you said Karen Read should be convicted, you have been screaming for 2 years that the defense relied on a dumb conspiracy theory you couldn't possibly believe. And then once she's acquitted, the first thing you want to do is create a conspiracy theory about the jury. You can't do that. That's not consistent at all. The jury did its job. If the jury didn't understand some of the evidence, that's the lawyer's fault. If the jury didn't understand that Karen Read's video clips were evidence against her, that's because Hank Brennan never said once at trial, these video clips are compelling evidence that you should consider against Karen Read. He didn't explain why he was putting them on. He could have done that in closing argument. He could have tied it all together. She gave statements at the scene. She gave statements to the press. Those are the statements of hers that you have to rely on as evidence, ladies and gentlemen of the jury. And those statements range from, I might have hit him, to I hit him. And that's the evidence you have to rely on, and that's what you ought to consider. And I don't care if you have conflicting experts in this trial. The defendant herself told you she hit him. I mean, I would have gone all over that in closing argument and the taillight and tried to minimize the expert witnesses and tried to maximize the science of the cell phone and the car data, which was good and favorable to the prosecution. But if the jury doesn't understand the evidence at the end of the day, it's not the jury's fault. Both sides pick the jury. Both sides screen the jurors. We get rid of any obvious knuckleheads. Trust me. Trust me, if there is an obvious knucklehead who shows up for jury duty, they are gone. Either one side or the other or the judge or all of the above gets rid of them. So that doesn't happen. If there's a juror that offends one of the sides, they get rid of them. They have challenges. Each side has peremptory challenges and can screen down. One of the things you can do with prospective jurors, you have their names. You can go look to see if they have any social media activity. And you can try to check them out and see what they're all about. You have big teams of lawyers. There are people who can go do that. You have no excuse for picking a bad jury, and you have no excuse for failing to explain your case to the jury. And you can't then turn around and say, the jury didn't understand, the jury's dumb, it's a terrible jury, the jury's rigged. I mean, come on. The jury's rigged? Stop. So I'd like everybody to leave the jury alone. I get it. Sometimes if the jurors want to go public, maybe a little bit they walk into it because if they're going to make comments publicly, people are going to take that on. But overall, leave them alone. They did their job. One side was going to be disappointed unless it was a hung jury again, and then both sides were going to be disappointed. It goes on. It goes on. So she's acquitted of everything but OUI, I think is what they call it in Massachusetts, or DWI as we would call it somewhere, driving while under the influence, which she clearly did. She got the minimum sentence, the sentence every first-time offender gets. That makes total sense in this case because that conviction is not for the death of John O'Keefe. It's just for It's just for drunk driving. I just had a glitch, but I hope I'm still recording. Anyway, it's just for drunk driving, so you can't give her more time. And I thought it was sensible of the prosecution not to ask for more time because they would have lost. And they already had a loss. They didn't need another loss. So all of that is over. The criminal trial is over. Karen Reed has prevailed. Alan Jackson has prevailed. David Unetti, Elizabeth Little, Bob Alessi, they have all prevailed. Like it or not, they did a good job. They did a good job. And I'm assessing mostly what happened inside the courtroom. I know there's a lot of stuff that happens outside the courtroom. And I know people have a lot of opinions about the role of social media and the role of content creators and the role of Turtle Boy. And I'm not addressing any of that here. I'm focusing on what happened inside the courtroom. I believe that the case was decided inside the courtroom. And that's where I think a case should be decided. We get a good prosecutor, we get good defense lawyers, we get a judge, we get a jury, we have a trial, the evidence comes in and the jury decides. That's how it's supposed to work, people, and that's how it worked. Now, there is civil litigation pending. Paul O'Keefe and the mother, Peggy O'Keefe, and I think they are suing both in their individual capacities and as representative of John's estates. They have sued the two bars that everybody went to, and they've sued Karen Reed. And that lawsuit was put on hold, which is what happens when you have a civil litigation and a criminal trial going on at the same time, because you can't take a deposition of the defendant who has the right to remain silent in the criminal case while the criminal case is pending. But now that the criminal case is over, they can take Karen Reed's deposition. And also, they've noticed the depositions of both of her parents and her sister-in-law. And you better believe they're going to be pursuing all kinds of other discovery. So that could yield a different result. Everybody knows about the O.J. Simpson trial, where the civil litigation yielded a different result than the criminal litigation or the criminal trial. And that could easily happen here. The burden of proof in a civil trial is preponderance of evidence. Is it more likely than not beyond a reasonable doubt, not 90%, or I know one juror said 99.9%, which is not beyond a reasonable doubt. But put that aside. Preponderance of the evidence is 50.0000001%. Literally, more likely than not. So could a jury find more likely than not that Karen Reed clipped John O'Keefe? Could a jury find more likely than not that that was the cause of his death? It's already been established she was drunk driving. I understand there may be a question about whether that applies to 12 o'clock in the morning or 5 o'clock in the morning, but at some point she was drunk driving. So you can extrapolate negligence pretty easily. It could be a different thing at the civil trial, and I'm going to keep an eye on that. I'm a civil litigator, so that interests me. There's a lot to happen in that litigation before it gets anywhere near trial. Don't expect a trial any day soon. There'll be fights, there'll be discovery, there'll be more fights, there'll be motions, there'll be more motions, there'll be a lot of stuff going on before you get a trial. And it could settle because I think there are insurance companies involved. There are the two bars involved. And an aside, I don't know about suing the bars. I think that must have been strategic, but weren't they serving a big crowd of law enforcement people? I'm not sure that you can sue the bars for serving this big group of law enforcement, and they were supposed to know who was driving and who wasn't, and they were supposed to cut off or stop Karen Reed from driving. I don't know about that. Also, it's two bars. How do you sue the first one if the second bar is where she really got drunk? I mean, that doesn't make any sense in the world. Why would you sue the first bar? So I'm a little skeptical about the bar part of that. I think that must be part of the strategy, and we'll see how it unfolds. And the civil case could be different. So that's where I am on this Sunday morning on the Karen Reed case. You know, whenever you involve a jury in the determination of legal rights, you have a range of possible outcomes. You just do. You can have the best case in the world, and if you walk into a court in front of a jury, you might not win. You can have the worst case in the world, and if you walk in front of a jury, you have a shot. That's just fundamentally what the deal is with jury trials. And this jury trial, from all accounts, worked hard, paid attention. They deliberated for 4 days. They asked questions of the judge. Every indication is that this jury did its job. Whether you like the verdict, whether you don't like the verdict, that's the verdict. And that's it for now. I'll see you down the road. We are adjourned.